There's in the form of a declarator as well, that it be declared that on a proper interpretation of Section 41, the powers conferred on an immigration officer or police officer are confined to public places and do not authorize warrantless searches, private places, that include the home and places of study, work or business, and require that an immigration officer or police officer hold a reasonable suspicion that a person is unlawfully in South Africa in order to request them to identify themselves as a citizen, permanent resident or foreigner. Do not permit the interrogation, arrest and detention of children under the age of 18 except as a measure of last resort and in a manner that is consistent with Section 28 of the Constitution. And of course, then other consequential relief that is mentioned under that prayer 14A. Now, the minister is the one that has been cited as a fifth respondent. The Department of Home Affairs is not cited, although they seek a certain order against it. But anyway, because of the constitutional challenge, they still had to cite the Minister of Home Affairs because he is the responsible executive authority tasked with the administration of the Immigration Act. So where there is a challenge of a constitutionality of legislation, you must cite the minister or the relevant authority to whom the administration of that act has been assigned. So I'm going to prefix my submissions first dealing with the interdict in the context of the allegation that the minister is colluding and the minister is supporting Operation Dudula. So I'll deal with that first. And then second, I will then deal with the constitutional attack of Section 41. And then I will also then deal with two other matters which do not necessarily fall under the Minister of Home Affairs, but because these are orders that are sought against the government of the Republic as a whole, I'll also deal with them briefly. That is the failure by the government to implement the NAP, and that is prayer 7, and as well as the declaratory order in prayer 1. But I'm just going to deal with them just briefly because these are not necessarily the orders that are sought against the Minister of Home Affairs. Well, there are orders, of course, sought against the Minister of Police, and the Minister of Police is represented, so that will be taken care of by the counsel who are appearing for the Minister of Police. There are orders which are sought against Operation Dudula. You recall yesterday, my lord, that an official from Operation Dudula came here asking that the matter must be postponed, and that was opposed, and the matter was not postponed. The relief sought against Operation Dudula, of course, it remains unopposed, and we have no interest in that relief ourselves. So we are not going to really bother the court and delay the court then by making submissions in respect of those prayers against Operation Dudula. So that is taken care of by the applicants who have made submissions in that regard. So before then I specifically deal with the prayer pertaining to collusion, I'm going to make the following general submissions so that they can underpin the approach that I'm going to take in demonstrating to the court that the applicants, whilst they may have had a noble objective to approach the court, but they decided then to just randomly shoot at everybody that they can think of shooting, and by so doing, they then allow their case to be convoluted and conflated instead of looking at the right target and deal with that target. Instead of looking at Operation Dudula, then they just shoot at everybody, even in situations where there are no facts to substantiate that. Let's take a simple example, my lord, of what counsel for the applicant submitted yesterday as a sweeping statement when he wanted to establish the prayer that the minister should be interdicted based on collusion. He admits that they have no evidence of collusion by the minister. And of course, they can never have that evidence, because in order to demonstrate collusion, you'll have to show that indeed the minister was colluding on the facts. So it can't be colluding on suspicion, collusion on speculation, collusion on rumor, or collusion on say-so. That is not how the law works. But what did he then say? He said, well, the department did have a meeting with Operation Dudula. What the department said is that as a Department of Home Affairs, we meet with various stakeholders and with everybody. It's not an offense, it's not unlawful, in as much as we'll meet with the applicant. We meet with everybody. But for one to suggest that meeting Dudula translates to collusion is an absurd proposition. So meeting Dudula without more does not translate to collusion. So that is what should be understood. But of course, the applicant, the submission that was made was that, well, whilst we cannot show you as a court evidence of collusion, but we're complaining about candor, that the department should have come and say that we are not colluding and will be satisfied. But was the department asked, are you colluding? So he says that it is now a complaint of candor. Candor, of course, is frankness. Be frank with us. Be open with us. So a candor and openness does not translate to collusion, because collusion is a very strong word. It has very strong connotations. It is a serious allegation which cannot be lightly made. It must be made when one has got evidence. It's the same as you accuse somebody of corruption, for example. It's not something that you can lightly make, or fraud. It is something that you must back with evidence. Because imagine, my lord, that now you've got an order which says the minister has colluded. And what it means is that this is a rogue minister who collude with criminals, who collude with people who commit offenses. And therefore then he's a criminal. So before you make such an allegation, you sit back and you ask yourself, do I have evidence to even make this allegation? If you don't have evidence, like the applicant now tells the court that we don't have evidence, then such a submission is reckless. and should be deprecated. Of course, then there was also amicus, or the amici who came to assist. But of course, then the amici came to assist the applicant. I will deal with their submissions at the end, of course, just briefly, because some already there is nothing much to say about what they say, insofar as they state what the law say. I will simply deal with those who, what they stated was going beyond the legal submissions, but venturing into evidence of new facts which they were not supposed to do. But we will deal with that at the end. So I would like to, with regard to the issue of collusion, my lord, to have regard to our heads of argument, which we submitted to assist the court. They are uploaded under page 09-121. Those will be our heads of argument. And if you turn to paragraph, as I understood yesterday, you said you have printed them, so then when I simply refer to the paragraphs, you'll be able to follow.
Indeed, Mr.
Yes, so when you look at paragraph 8 of our heads, where we point out what the applicant's case, insofar as it says that the minister must be interdicted, is that the DHA alleged collusion with Dudula, but in fact they specifically say that the minister, and but we have said, and we have referred to paragraph 10 of the answering affidavit, where it is specifically denied that the minister is not in collusion. Initially, my lord, what was alleged was that the department has meetings with Dudula and correspondence exchange between Dudula and the minister or the department. But of course, the applicant does not say that we are aware of that as a matter of fact. Then they say that because you had a meeting with them, it means that you are communicating with them, you are corresponding with them. And my learned friend for the applicant yesterday actually said that they then delivered a Rule 3512 and asking if then there is correspondence that took place between the department and Operation Dudula, and if so, they were asking for that correspondence. And he said correctly that Rule 3512 was answered or responded to by saying that there was no such correspondence between the department and Operation Dudula. So the allegation of correspondence then cannot be substantiated. And the applicant accepted that explanation because they didn't take the matter any further. So that is why in this court yesterday, there was no longer any submission about the correspondence that has taken place. And if indeed there was such a correspondence and they genuinely believe that it existed, one would have expected them to have taken it further, because there are remedies in terms of the rules. When you deliver Rule 3512 and you are not satisfied with the response, then you take the matter further and you ask that the court must compel that party to make that documentation available, because you say that it is important for the prosecution of your case. So all what we are submitting insofar as the allegation that there was collusion is that there is no evidence to substantiate that. The applicant accepts that there is no evidence, but the applicant says that because this is a constitutional matter, you must not look at the evidence. So he even went to an extent of saying that we are treating this matter as a commercial matter, and then as a commercial matter, they don't have to prove anything. That's what he's saying. So they must just allege and then leave it there. But that is absolutely wrong. In every matter, the applicant must set out the allegations which are proven, and based on those allegations which are proven, then the court applies the law to those allegations in order to see whether an order can be made. It is as simple as that. To say that Plascon events doesn't apply when somebody is alleging to be coming under a constitutional matter, that you don't have to apply it, is simply wrong. Because Plascon events is a tool that has been fashioned in order to assist courts in motion proceedings, given that you do not have the benefit of the witnesses who are to be cross-examined. So that is the tool that was fashioned for the benefit of the court, to say that look at the allegations, look at how they are answered, and the manner in which they are answered. Are the answers of such a nature that they are far-fetched and untenable, that they fall to be rejected outright? That is the basic law that is applied in motion proceedings every day. And so...
And that specifically relates to factual issues.
Exactly, absolutely. So where there is factual issues, you can't run away from it, because the court is got to be there.
The same principle applies in relation to constitutional court matters.
Absolutely.
You need to have a factual basis, and the facts on which one bases your judgment is the ordinary principles apply relating to evidence.
Absolutely, my lord.
Yeah.
Absolutely. I mean, then for instance, in motion proceedings, well, I mean, Justice Harams then said it very nicely in the matter of Zuma, National Director of Public Prosecutions versus Zuma, in paragraph 26, then when he again cautioned then the courts how to approach motion proceedings, to say that probabilities don't come into play there, because motion proceedings are designed to deal with legal disputes which arise from common cause facts. Is it then this comes from where? No, it comes from where? Oh, okay, all right. Yeah, that's paragraph 26, yeah. Because I'm actually given that paragraph 26 of Zuma, and I can simply read it quickly. Motion proceedings, unless concerned with interim relief, are all about the resolution of legal issues based on common cause facts. Unless the circumstances are special, they cannot be used to resolve factual issues because they are not designed to determine probabilities. It is well established under the Plascon events rule that where in motion proceedings disputes of fact arise on the affidavits, a final order can be granted only if the facts are in the applicant Zuma's affidavits, which have been admitted by the respondent's NDPP, together with the facts alleged by the latter, justify such an order. It may be different if the respondent's version consists of bald or uncredit-worthy denials, raises fictitious disputes of fact, is palpably implausible, far-fetched, or so clearly untenable that the court is justified in rejecting them merely on the papers. So there's been no suggestion that the minister's affidavit is of such a nature that it is palpably false, and that it sets out allegations which fall to be rejected outright. So once the collusion or the support by the Minister of Operation Dudula, which was busy committing criminal offenses, cannot be established, we don't even go to the next step of whether an interdict ought to be granted. And so because it simply doesn't arise. Now, the one that to me, my lord, is quite important, and it requires a serious consideration by the court insofar as it involves the department. It is Section 41 of the of the Immigration Act, and that's the one that I'd like to spend a bit of time on it. Well, Section 41, I have printed the Act so that just for the convenience of the court, I've printed the Act in its amended form because I'm going to juxtapose between sections. First, my lord, let us understand what is the applicant's complaint about Section 41. We have seen it from the amended notice of motion under Prayer 11 because they say that the first complaint is that they say that it authorizes warrantless searches in private places. So Section 41 is problematic constitutionally because that's what it does. So we have to read it, of course, and then interpret it in the context of what the Constitutional Court said in Cool Ideas and what the Supreme Court of Appeal said in Endumeni. So may we go to Section 41 in that Act that I gave to you, my lord. And by the way, my lord, Section 41 was amended. If you just turn the page to the next page at the top there, you'll see there it says amended Section 41 substituted by Section 40 of Act 19 of 2004. So there was the original Section 41, and I'll just tell your lordship the difference, but it is right at the end. But let's look at the Section 41 as it is applicable currently. When so requested by an immigration officer or a police officer, any person shall identify himself or herself as a citizen, permanent resident, or foreigner, and if on reasonable grounds such immigration officer or police officer is not satisfied that such person is entitled to be in the Republic, such person may be interviewed by an immigration officer or a police officer about his or her identity or status, and such immigration officer or police officer may take such person into custody without a warrant and shall take reasonable steps as may be prescribed to assist the person in verifying his or her identity or status, and thereafter, if necessary, detain him or her in terms of Section 34. So when we apply the interpretation tools, the first question that we ask ourselves is, what does Section 41 seek to achieve? One, it seeks to achieve the identification of persons. That's all what it does. It does nothing more than that. It seeks to achieve the identification of persons. Not identification of immigrants, not identification of illegal immigrants, but identification of persons. That's why it starts by saying, when so requested by an immigration officer or a police officer, any person shall identify himself or herself as a citizen, permanent resident, or foreigner. And this also, it becomes apparent, whilst of course headings are not necessarily to be used to interpret a statute, but they do throw some light. In this case, it does not even have to be but I'm just pointing out to your Lordship, if you can go back to section 38. You'll see that where section 38 starts, the subheading is duties and obligations, and in section 38 up to section 46, they fall under this subheading of duties and obligations. So I may ask the question differently and say, what is required of persons insofar as the Immigration Act is concerned in respect of their duties and obligations? And then you will find duties and obligations on each of these sections. Like for instance, section 38, it tells you what are the duties and obligations of the employers. Then employment. So that's the obligation and the duties of employers. Section 39, what are the duties and obligations of learning institutions? 40, the obligations of keeping of registers of lodgers by certain persons. 41, the obligation to identify yourself. That's all it does. It's the obligation to identify yourself. Are you refusing to identify yourself? Well, the excess, you've got a duty to identify yourself when you are asked. And when you turn to 42, aiding and abetting of illegal foreigners is also then an obligation, a duty that you cannot aid and abet illegally. 43, obligation of foreigners. 44, obligations of organs of state. Even organs of state have got duties and obligations. 45, obligations of other institutions. And of course, 46 was repealed in 2004, and it no longer exists. So now let's go back to the impugned section, which is section 41. First, it imposed duties and obligations. And mind you, my Lord, this is not duties and obligations to the immigration officer or to a police officer. It's duties and obligations to persons to identify themselves when they are asked. And we'll come back to that, because remember that the other complaint by the applicant is that the flaw in section 41 is that the reasonable suspicion, the reasonable grounds is only on the second sentence when it's supposed to be also in the first sentence. Of course, when you look at section 41, it is divided into three components. The first one, which ends with that comma after or foreigner, is the first component of it, which is about obligation to identify yourself. You don't have to have a reasonable ground. It is the law which says that everybody, if I introduce myself that I am an immigration officer, police officer, can you identify yourself, then you do so. And in fact, if you look at it in practice, in real life, they will do that all the time. I fly to Durban and then they want me to identify myself at the airport. Otherwise, I'll never go through. Then I have a choice. If I don't want, then I'll not go through. But if then that identification is of such a nature that it carries certain obligations, then there may be consequences for that, and we're going to come to the consequences later, because it has three components. But the first one is identification. The second component is the one which follows now, and that is the one where the power of the immigration officer comes in. Because then it says, and if on reasonable grounds such immigration officer or police officer is not satisfied that such person is entitled to be in the Republic, if on reasonable grounds. So first, you have asked me to identify myself. I have done so. then you must have reasonable grounds. Then for you to keep me further, you must have reasonable grounds. Because once I've identified myself, then you must leave me go. Let me go and don't waste my time. You hold me only if you have reasonable grounds, and that is established on the second component. As such person may be interviewed by an immigration officer or a police officer about his or her identity or status. For instance, I may have said to, and so no, I don't have any identification with me. And then he can now exercise his power on the second component, but he must have a reasonable ground. Then to do that you are going to interview me. But even that interview, let's look at the safeguards which we find even in the very same section 41. It says, so you interview me on the issue of my identity or my status in the Republic, and such immigration officer or police officer may take such persons into custody without a warrant. Because at that stage you have established a reasonable ground. You can't then do that if you have not established a reasonable ground. That is the second component. And that's where now the power of the immigration officer comes in, and that power must be exercised with circumspect and with all the constitutional rights which are embodied in everybody. You do it with dignity. You must do it in such a way that you do not infringe on the person's constitutional rights. The third component, which is the last one now, is, and shall take reasonable steps as may be prescribed to assist the person in verifying his or her identity or status. So we can see really what this identification seeks to achieve. Of course, then, in the Republic, there are citizens, there are non-citizens, and all of them are entitled to be in the Republic, but to regulate the presence of persons in the country, the Immigration Act then is of such a nature that people can be asked to identify themselves, and if they are not able to do so at that particular moment, the immigration officer must assist that person to identify himself or herself. Let me give an example of a citizen. Well, I'm a South African, that's what I'll tell the immigration officer, but I don't have any identification, I don't have my driver's license, I don't have my ID card, but I have it at home. He can't just lock me up and say you're lying. He must then, if I don't have a car, he must drive me home so that I can show him my identity card. If I have a car, then he must then say, I'll follow you home. So that is where the assistance come in. If, for instance, is a foreigner who says to him, I don't have anything with me, but I'm an asylum seeker, he must actually take him to the office, the refugee reception office, and say that he is an asylum seeker. Can you help him so that he can be documented? That is the duty that is imposed on the immigration officer. And of course, if that person on the explanation doesn't fall into any of the categories where then he says, I'm an asylum seeker and so on, but he is an illegal immigrant, then detain him in terms of Section 34. And that's where now then the power of detention comes in terms of Section 34. And we have to look at what is it that Section 34 say. If we go back to Section 34, deportation and detention of illegal foreigners. So, remember, my Lord, then when I was looking at Section 41, I located it within the subheading of duties and obligations. But let's look at where Section 34 falls in. And when we go back to Section 32, which deals with illegal foreigners, then it says enforcement and monitoring. So under Section 41, then it's an identification, and once you have completed that process, then the power of enforcement kicks in, and that starts from Section 32, where it tells you who is an illegal foreigner. Any illegal foreigner shall depart unless authorized by the DG. Section 34. Without the need for a warrant, an immigration officer may arrest an illegal foreigner or cause him or her to be arrested, and shall, irrespective of whether such foreigner is arrested, deport him or her, or cause him or her to be deported, and
They should receive your complaint.
100%. That is the duty.
All good and well for the SAPS to say, well, you know, we did wrong and you should have reported us, right?
Yes,
I don't know
ma'am.
if that's a good enough answer. No.
No, but that, my lord, unfortunately, like any other institution, I mean, there are pockets of of places that are simply incompetent, and there are, like in any other institution, there are good apples and bad apples. The SAPS is no different. So on that score, where there was that kind of conduct was encountered, it was incumbent on the applicants, also as responsible inhabitants of the Republic, to report it. Like it is responsible for all of the people in the Republic of South Africa to, once you witness a crime or if a crime is committed, to report it, my lord, to facilitate the investigation.
Well, it's their constitutional obligation to deal with that matter. A crime is being committed by all accounts, and they should deal with it and not just ignore people who arrive at the police station.
100%.
I mean, that's the point made on behalf of the applicant.
100% made, and we say that we can't, they've denied that they turned it away, but to the extent that the affidavits that was provided is so extensive that the applicants did not get the required assistance that they needed, they should have then, at the very least,
Yes.
escalated the situation.
Yes.
It's all good and well to say that something had transpired, the police didn't do anything, but it's also incumbent on us to escalate those situations, and that is precisely why IPAD was established, to police conduct, unfortunately. Well, then they also deal with the issue of Orange Grove, and I think this is the police station where the applicants perhaps received the most assistance. We detailed that several dockets had been opened. One, which was opened by the Mr. F.A., the deponent to the affidavit. That matter was properly investigated. A charge was laid, an arrest was made. The prosecution declined to prosecute. Subsequent to that, the matter went to mediation. So, my lord, we've done our due diligence. We've done what we needed to do in those circumstances. Following that, there was further investigation where there was an allegation that something had happened to a pregnant woman. The police came back and provided 2 alternative case numbers to the extent that they don't have the records of a complaint being laid with that definition or those circumstances being reported. The only complaint they had, they provided the details to the applicants with the case number in question. And even in the incidences of the 13th of June, the SAPS provides the details in relation to cases that were opened with respect to intimidation and damage to property. So it's clear, my lord, on the information provided by the SAPS and the applicants that indeed they did receive assistance at Orange Grove. Their claims were investigated, In one of the instances, unfortunately, the prosecution declined to prosecute, but the blame for that can't be laid at the feet of the SAPS. Another vital issue that they raised was the issue of Yeovil. What happened at Yeovil is the Operation Dudula attempted to shut down stores. Vispol was alerted. They attended. So key issue here is attempted. When the police arrived, they prevented harm to the shop owners and to the individuals present. 2 days later, there was a fire. The applicants allege that there was an arson attack and no one had been arrested. The police accepted no one had been arrested because there was an inquiry launched into the fire. An inquiry document was opened that your Lordship will see at pocket 1185, the entire report from the City of Johannesburg management. As part of that report, there are statements taken from everybody that was at the scene or after the scene, or there was a consent. One of which is a statement that indicates that a stove had been left on and there was a fire in one of the shops which led to the fire. The City of Johannesburg reports also indicate that the cause of the fire was undetermined. So in this circumstance, yes, there was no arrest, but there was no arrest because there's no evidence of an arson attack. If there's no prima facie evidence that anybody started the fire, the police, unfortunately, is not at liberty to just arrest anyone. Now, my Lord, if you look at then there were further incidents in relation to the clinics, where the SAPS was showed up. Again, once again, no complaints were laid. And then other issues that deals with the instigation of or inciting violence on the media. Again, we ask the applicants to also be diligent and say, at no point did anybody open a charge to that extent. For any xenophobic hate speech that was divulged on social media platforms. No, they didn't provide us with any cases on the papers before the court. I can't identify any instance where there was a criminal case being opened. And I suppose, my Lord, the most unfortunate incident in which the applicants deal with is the untimely unaliving of Mr. Nyati, which had taken place in Diepsloot, to the extent that they say that those who were arrested were released on bail and no one has been convicted of the murder. That is true, my Lord. But no one has been convicted of the murder because the matter was handed over to, once again, the NPA. There was an investigation. There was an arrest. Individuals were charged. The matter was struck from the roll. Because the NPA didn't secure any witnesses. Now, my Lord, if the issue before you today is that we don't investigate, that is clearly not the case. We've illustrated to you now that there's investigations where we have been called upon to show up and maintain peace, like in Maboneng and Resettenville, where the visible policing got involved when they were called to monitor situations where immigrants were being threatened. They show up, they monitor, they leave. There was no act of violence perpetuated in their presence. Now, my Lord, if you have regard, my learned friend did yesterday deal with the matter of AK versus Minister of Police, wherein it deals with the purpose of an investigation is not to secure a successful prosecution, but it's for the police to act diligently. So now we've illustrated we've acted diligently, but it still did not lead to successful prosecution. So the blame for and accountability can't be squarely laid at the feet of the police on these facts, my Lord. Clearly we've investigated, we've handed over the dockets. It's the NPA's responsibility to ensure that the criminal justice system now runs its course from that perspective. And in regards to the applicants stating that the Minister of Police has taken a stance of a spectator as opposed to investigating crimes. My Lord, if we look at the general principles, the general principles of what is provided for related to investigations by the European human rights. It's first that the investigation must be capable of, firstly, ascertaining the circumstances in which an incident took place. That goes hand in hand with reporting. So you can't come to court and say the police didn't investigate when you don't even tell us that you've reported. That simply doesn't follow. My Lord, I'm reading that from my heads of argument, so I apologize. Even the AK matter is dealt with in paragraph 43 of my heads of arguments. The issue of the European Court of Human Rights and the principles in relation to investigation is dealt with in paragraph 44, where it speaks to ascertaining the circumstances in which an incident take place. And this is why it's everyone's obligation to, when you witness a crime, when you encounter a crime, to report a crime. This is so the incident can be, under the circumstances, be pinpointed at the very least to lead to investigation and further lead to identification and punishment. So on several occasions, based on the applicant's own papers, there's no evidence that any of the victims laid any complaints, in particular to Jabavu, Maboneng, and Jepi, where it is alleged that the police did not investigate claims. And where so claims were laid, or where the applicants were turned away, as they allege in Jepi, again, my Lord, we are of the view, if we have regard to the principles as laid out in the Oak Bay, Minister of Finance versus Oak Bay, that is also in our supplementary heads of arguments, which deals with the requirements of a declarator. There has to be, at the very least, the existence of a dispute. A dispute can exist by any means. So if they had laid these complaints with IPID, that dispute would exist. But we find out now through court papers that these issues had arisen. In addition, my Lord, as I previously indicated, the availability of alternative remedies. Once again, there's an alternative remedy. To that end, my Lord, the SAPS has detailed numerous instances where it investigated complaints, where it has acted diligently, and where it complied with its constitutional obligations. This court is not at liberty on these facts to come to the aid of the applicants to grant this declaratory. The SAPS doesn't act in a vacuum, unfortunately, and what they're trying to do is bound the SAPS as a nation to a few incidences that had transpired in Johannesburg. Unfortunately, my Lord, that's impermissible. There's simply not enough evidence for your Lordship to come to the conclusion that the SAPS has failed in its constitutional obligation to investigate and combat crimes in relation to foreign nationals. My Lord, and then also I'll briefly deal with the issue of the uniforms, because it is also dealt with in this under this umbrella for the SAPS. So, my Lord, if you have regard to what is the SANDF Act, the SANDF Act makes it clear the defense uniform is highly regulated. The Act speaks of a distinctive marking and crest, not merely camouflage or apparel resembling military outfits. So on that score, my Lord, it doesn't follow. This is unjustified. At best, the SANDF is best placed to identify what is strikingly similar to their uniforms, bearing regard to the watermarks and the crest that is required. And throughout the applicant's affidavit, they speak of that members of the first respondent always show up in T-shirts and camouflage or military outfits, uniforms as they state, because the Act, Section 8A, states that no person shall wear any form of apparel resembling any of the uniform worn by members of the SAPS and the SANDF. This provision is akin to the provisions in the SAPS Act, which deal with impersonation. The purpose of the provision is to eliminate confusion and impersonation of officials in state authority. Now, my lord, there has never been any confusion on the papers that at any given moment, whether or not the members of the first respondent were acting with the necessary authority of the SANDF, or where they were confused for the SANDF. At any given moment, they were always identified as members of Operation Dudula. There was never any confusion to that end. The steps in this paper state correctly that camouflage is unfortunately readily available in all the shops, and they simply cannot arrest anyone for wearing camouflage. What we need to establish is whether or not the wearing of that camouflage constitutes the uniform resembling that of the SANDF. And even on the examples of pictures that were provided by the applicants, there's no such. In the pictures, my lord, as you will see when you go through the papers, especially from Annexure 42, yes, my lord, you'll get at pocket 022331. That's where your lordship will find it. But my lord, I'll just quickly show you. My lord, from the pictures, if we look at Annexure 42, there's one person there in the front wearing a camouflage hoodie, and he's wearing a hat. That's not a military hat. The people behind him are all wearing white t-shirts, and some of them are wearing camouflage caps. At Annexure 43A, my lord, these ones aren't even wearing camouflage. They're wearing a camouflage hat with jackets, just black and white jackets. I suppose the most daunting one would be the one that they've attached at Annexure X44, which is in Santa Lux, where he wears a camouflage hat and a brown bomber jacket. That is not akin to a military uniform, my lord. They have attached the evidence of a military uniform at paragraph in Annexure 51. There's no confusion under the circumstances. So yes, the SAPS should, in terms of the Gatherings Act, if it finds that the uniform that is being worn strikingly resembles that of a SANDF uniform, should definitely take action. But on these facts before the court, it simply could not do that. So in that regard, my lord, they failed to make out a case for the relief that is sought in terms of the Gatherings Act. But even if they succeeded, my lord, how would it be applied? Even if they were to succeed to say that camouflage strikingly resembles military uniform, how would it be applied? We know of several organizations that also, unfortunately, wear camouflage, which is akin to hunting gear and the farming activity. That's all part and parcel of camouflage and being readily available. But on the papers, there's simply no confusion or any kind of inference that can be drawn that the conduct or the apparel worn by the first respondents, and it strikingly resembles that of the SANDF uniform. That is not on the papers, my lord. And on that basis, the SAPS cannot simply arrest anybody that is wearing camouflage. My lord, those are my submissions in respect of prayer 8 and prayer 9, and to a large degree, maybe prayer 6. Prayer 4, my little colleague will now deal with the outstanding issues in relation to the SAPS. I think there's only one outstanding prayer in relation to us.
Thanks, Susan.
As the court pleases, my lord, in respect to the relief sought in prayer 4, I just want to emphasize one thing. It's in relation to Section 104(5) of the Defence Act 42 of 2002, which states, any person who, without the written authority of the Chief of the Defence Force, possesses or wear any uniform or part thereof, distinctive mark or crest that has been determined, that's what I want to emphasize, my Lord, that has been determined by the Chief of the Defence Force as official attire in the Defence Force. My Lord, as the pictures were shown by my colleague, Ms. Isaacs, there is no resemblance of the camouflage attire worn by members of Dudula and those of the SANDF. My Lord, and in these pictures, I think it's KX 56, my Lord. The applicant attached the pictures of the soldiers in the defense uniform, my Lord. And if one as regard to the pictures, my Lord, there's no resemblance, none whatsoever, my Lord. My Lord, just by way of an example, not that I'm arguing from the back, I've got a camouflage cap. You can buy it anywhere. I bought it from Jeep, and I embroidered it because I'm a member of the Jeep Club, Limpopo Wranglers Jeep Club. So if I find myself in the midst of the members of Dudula, then I'll be arrested and be guilty of wearing that cap, my Lord. So that cannot be correct, my Lord. Then, my Lord, my learned colleague, Advocate Mukari SC, dealt with the issue of the interpretation of Section 41 of the Immigration Act. My Lord, we align ourselves with the submissions, also with the submissions relating to the interpretation in respect of the minor children, my Lord. So, my Lord, what I'll do, I'll just take it from where he left it off, my Lord. And deal with the my Lord, deal with the just a moment. Deal with the comparative, my Lord, with other countries, my Lord, of the application of all the powers entrusted in the immigration officials, my Lord. In our case, my Lord, we refer to Botswana as the first country. My Lord, that is contained in our supplementary submissions, start from 09-239, my Lord. That's where we're dealing with a comparison with other countries, my Lord. Just a moment, I'll get there, my Lord. Start from paragraph 38, 09-251, my Lord.
No, paragraph 37. 37.
My Lord, in Botswana, the powers of officials are set out in Section 6 of the Immigration Control Act, which provides 6. Examination of suspected illegal immigrants. 1. A police officer or traditional authority who suspects that a person is an illegal immigrant may at any time require the person to present himself or herself to an immigration officer and submit an examination. 2. Notwithstanding the provision of subsection 1 and subsection 307, 1 of the Criminal Procedure and Evidence Act, a person who admits to being an illegal immigrant shall pay to a police officer an admission of guilt, fine, or of not less than 300 pula, but not more than 10,000 pula. 3. A person who is required under this section to submit to examination shall be examined by an immigration officer in accordance with the provision of Section 5. My Lord, at paragraph 39, in Namibia, the powers of the immigration officials are set out in Section 8 of the Immigration Control Act as follows. 8. Powers of immigration officers in respect of certain persons presenting themselves, 1. For purpose of ascertaining any matter referred to in Section 7, an immigration officer may require any person referred to in that section, A, to answer in writing or otherwise such questions as the immigration officer may put to him or her, which are relevant to his or her identity, citizenship, or country of origin, as the case may be. B, to make and sign a declaration in prescribed form. C, produce documentary or other evidence relevant to his or her claim to enter or be in Namibia, or that his or her entry into or his or her presence within Namibia will not be unlawful. D, to submit to any examination or test to which such person may be subjected under this Act. E, if it is suspected that such person is afflicted with any disease or physical infirmity which under this Act would render him or her a prohibited immigrant, to submit an examination by a medical practitioner designated by the minister. 2. Any declaration made by any person under subsection 1 shall, notwithstanding anything to the contrary contained in any law relating to stamp duty, be exempted from such stamp duty as may be imposed by law in respect of affidavit and solemn or attested declaration. Section in paragraph 40, my Lord, Section 4, United Kingdom Immigration Act provides information and documents. 4.1, it shall be the duty of any person examined under paragraph 2 or 3 above to furnish to the person carrying out the examination all such information in his possession as that person may require for the purpose of that or any other person's function under that paragraph. 2. A person on his examination under paragraph 2 or 3 above by immigration officer or on his examination under paragraph 3 above may the designated person shall, if so required by an immigration officer or designated person, A, produce either a valid passport with photograph or some other document satisfactory establishing his identity and nationality or citizenship, and B, declare whether or not he is carrying or conveying or has carried or conveyed documents of any relevant description specified by the immigration officer or designated person, and produce any documents of that description which he is carrying or conveying. In paragraph B, relevant description In paragraph B, relevant description means description appearing to the immigration officer or designated person to the relevant for the purposes to be relevant for the purposes of the examination. My Lord, in paragraph 41, in addition, the UK Act stipulates an immigration officer has the authority to request any person examined to submit to further examination through written notice. This further examination may include verifying the individual's identity, any entry legality, compliance with the leave condition, and any prohibition or restriction on their return. At paragraph 42 of the head, my Lord, we're saying when one examines the scope and authority conferred by Section 41 upon immigration officials and members of the South African Police Service, it becomes evident that these powers are no more burdensome than those granted to the immigration officers in our neighboring countries' powers, which are similarly not limited to public spaces. Accordingly, the purpose of Section 41 is to enable the verification of individuals who are present in the country without valid identification or documentation. In such instances, their presence is deemed unlawful, and it is appropriate for law enforcement authorities to exercise their powers not only in public spaces but where necessary in private ones as well. My Lord, paragraph 42 is saying, put differently in terms of immigration legislation, which must be read together with and in uniformity with other accompanying instruments, a foreigner must prove their right or entitlement to be in the country. Now that entails furnishing the relevant authorities and including members of the South African Police Services with identifying documents such as passport. In case where one is dealing with refugee, the Refugee Act kicks in, and one may provide the relevant document in terms of the Refugees Act. That is, there is a positive requirement imposed, and a failure to comply with this positive obligation attracts legal conclusion of non-conformity. That is a legal deduction one is presumed to be unlawful in the Republic. My Lord, those will be the submission in addition to the interpretation of Section 41 in comparison to our neighboring countrymen. As the court please, those will be our submissions. Thank you.
It is necessary to address the submission of two sets of respondents, some aspects of reality, a fairly sprawling set of reliefs. But we shan't repeat anything we said in our final submission. We'll address the issues that are at the heart of this matter. Lord, we propose to address 7 issues in reply, some very briefly. The first is the non-citation of the Director General of Home Affairs. The second is the SAP's failure to investigate or discharge its functions. The third is the collusion, support or instigation relief. The fourth, Section 41. The fifth, very briefly, the National Action Plan. Sixth, the military uniforms. And finally, my Lord, a word on human rights defenders. My Lord, we begin then with the issue of the non-citation of the Director General, which was raised now in oral argument by our learned friends for the Minister of Home Affairs. Lord, we submit that it's a point that doesn't avail them for 2 primary reasons. The Minister is the executive authority responsible for the department in terms of Section 85(2) of the Constitution. And so the Minister is appropriately cited. But secondly, my Lord, substantively and fundamentally, the Director General personally deposed to the answering affidavit on behalf of the department. And my Lord, that answering affidavit throughout is framed as the Department of Home Affairs denies, admits, and so on, the Department's position. That is the approach of the Director General in the affidavit. So it's really a point of form over substance, my Lord. The interdict in any event is sought against the Minister and the Department, but it's obviously understood that it's not concerned with the Minister personally. Much of the conduct in issue is that of officials. So, my Lord, we submit that it is appropriate to make that order against both the Minister and the Department. Lord, turning then second to issues of the police failures to investigate and prosecute. Lord, there were some concessions made here belatedly on behalf of the SAPS, that the SAPS has failed in its obligations to open cases and investigate them in certain instances, in particular the Jeppe police station incident following the eviction at Msibi House. But, my Lord, what characterized my learned friend's submissions throughout on this issue on behalf of the SAPS was selective invocation of examples where the SAPS either was not present or did act. The overall pattern, my Lord, on the papers is overwhelming, and it's set out in our supplementary note which tabulates the papers. It's an overwhelmingly supine response, which culminates in the evidence that there have only been 2 prosecutions of Operation Dudula members, one of them with nothing to do with its activities, and the other in Durban. The SAPS can't point to a single successful investigation and prosecution. They seek to lay the responsibility for that belatedly at the feet of the National Prosecuting Authority, my Lord. But with respect, it all begins with opening cases, investigating them, and referring the matters to the NPA. And the overwhelming pattern is that they have failed to do so. Lord, in terms of my learned friend's submissions, much of it departed from the papers in relation to this issue and with respect to several of the others. There was reliance on documents contained in the Rule 35 response, that wad of documents delivered late and uploaded onto case lines, for example, in relation to the Yeovil fire. But, my Lord, there's no affidavit on those issues. And so my learned friend is now relying on documents that were just delivered in response to a Rule 35 request. But more fundamentally, my Lord, and this is illustrated by the events at Diepsloot, there was a failure to investigate, and regrettably, my Lord, these failures are interwoven, interconnected with the collusion with Operation Dudula. And the Diepsloot incidents really highlight that, my Lord. I must begin, my Lord, by making the submission, and it may be that my learned friend sought to do so to find a softer term out of respect for Mr. Nyati. But he was murdered, my Lord. He was not unalived. He was brutally stoned and burnt to death in front of a crowd that filmed and laughed, following an Operation Dudula gathering that day in Diepsloot that incited those events. And my Lord, what was the SAPS response? First of all, it was to conduct an operation going door to door, asking people to verify their status, including instances later reported to Parliament of officers performing the elbow test. And my Lord, the reference to the parliamentary question on whether the SAPS had disciplined one officer reported for using the elbow test in Diepsloot, going door to door and asking people to give the name of the word for elbow in the vernacular. The reference is at 022182. And my Lord, the position on the papers is that the relevant SAPS officer was not disciplined. So, my Lord, my learned friend made, with respect, glib submissions about non-reporting, that people are not reporting offences. The evidence on the papers is that the SAPS in Diepsloot went in afterwards on a witch hunt operation verifying people's status. It can be little surprise then, my lord, that witnesses don't come forward and that cases are difficult to prosecute. And my lord, the relevant supporting affidavit that my learned friend refers to, she indicated that the representative of one of the applicants who went to Diepsloot on that day didn't say who they spoke to. They spoke to Mr. Nyati's widow, my lord, who fled the country because she was afraid that the same people would come after her for having spoken to the media. So, my lord, we submit that in relation to this issue of the failures to investigate, it is simply constitutionally inadequate to say there may be pockets of incompetence and that reports should be laid with IPID. There is a constitutional duty rooted in Section 205 of the Constitution on the SAPS to prevent, investigate, and ultimately take the actions necessary for the prosecution of crimes. And the SAPS has fundamentally fallen short of that duty, my lord. It failed to discharge it. Lord, I turn then to the relief in relation to collusion, support, or acting at the instigation. Lord, we emphasize that all three terms are set out in the order. I'll circle back at the close on this issue on the framing of that order. But let me first deal with the arguments in answer and our reply. The Department of Home Affairs persists in saying that there's no evidence. Lord, there was no meaningful answer regarding the lack of candour. We've given the reference in our heads, my lord, at paragraph 118, to the department admitting, not just meeting, but also admitting communicating with Operation Dudula. So they make both admissions, that they communicated with Operation Dudula and met with them. My learned friend made the submission that the papers reflect that the department's answer was that there was no correspondence exchanged. With respect, my lord, that's not quite what they say in either their answering affidavit or their response to the Rule 35 notice. My lord, what they actually say is that there are no records in their possession of any correspondence. Not that there was no correspondence, but they now seem to have no records of it. And my lord, that appears in the answering affidavit at 06-273, paragraph 95, and in the Rule 35 response. Provide the reference momentarily, my lord, I've just misplaced it. Lord, fundamentally, we accept that Plascon Evans applies. We're not seeking to depart from it. But there are fundamental principles that have been developed by our courts in relation to Plascon Evans. It's not the straightforward respondent's version prevails. Well, that's the Duffer's Guide to Plascon Evans. The principles are more nuanced, and we've given the authorities in Matatiele and Public Protector regarding the duties of the state in constitutional litigation, the duties of candor, my lord, to make full and frank disclosure. Well, if I can just provide the reference to Home Affairs' response to the Rule 35 notice, it's at 11-81, and it's really in the same. Oh, sorry, my lord, that's the SAP's response. We'll provide the Home Affairs one in a moment. Lord, we have one further reference which is fairly apposite on these issues of failing to disclose facts, in particular failing to disclose meetings. And, my lord, that is the matter, another constitutional court decision of Public Protector versus South African Reserve Bank, 2019 Volume 6, South African Law Reports 253, decision of the Constitutional Court. And the key paragraphs, my Lord, are at 174 to 190. This is the majority judgment. My Lord, the matter concerned the review of a report of the Public Protector, which among other things recommended that the Constitution should be amended to change the mandate of the South African Reserve Bank. One of the issues in the matter, my Lord, was that the then Public Protector had conducted meetings with state security officials which had not been disclosed in her report and were very belatedly and partially disclosed to the court. And, my Lord, at paragraphs 174 to 190, the majority ultimately grants de bonis costs against the Public Protector for that reason. But what is helpful, my Lord, is that, again, the court reiterates the duties of candour and frankness and points out the aspects of the meeting that the Public Protector has not disclosed, which are the same sorts of issues that are in question here. When, where, with whom, what did you talk about? So, my Lord, we submit that that's one further helpful authority. But, my Lord, this principle has always existed in similar form even at common law, and in Whiteman, my Lord, which is the leading authority on the exceptions to Plascon-Evans relating to bald denials, at paragraph 13. And, my Lord, the citation of Whiteman is 2008, volume 3, essay 371, decision of the Supreme Court of Appeal, and the relevant paragraph is paragraph 13, dealing with a real, genuine, and bona fide dispute of fact. And, my Lord, there the Supreme Court of Appeal held a real, genuine, and bona fide dispute of the fact can exist only where the court is satisfied that the party who purports to raise the dispute has in his affidavit seriously and unambiguously addressed the fact said to be disputed. There will, of course, be instances where a bare denial meets the requirement, because there is no other way open to the disputing party, and nothing more can therefore be expected of him. But even that may not be sufficient if the fact averred lies purely within the knowledge of the averring party, and no basis is laid for disputing the veracity or accuracy of the averment. When the facts averred are such that the disputing party must necessarily possess knowledge of them and be able to provide an answer or countervailing evidence, if they be not true or accurate, but instead of doing so rests his case on a bare or ambiguous denial, the court will generally have difficulty in finding that the test is satisfied. Well, that's really the key aspect, but it's a well-settled principle, my Lord. It's the locus classicus. So we submit, my Lord, that what we do have in on the papers are those admitted facts around the SAPS escort operations, the Department of Home Affairs meeting, and the joint operations that were conducted. And, my Lord, it's simply not good enough to say there were escort operations conducted at some of the gatherings without saying who requested them, on what basis, who authorized that request, how they were conducted. My Lord, we'll talk in a moment about the strength of the term collusion, but the term escort it has friendly connotations, my Lord. Not the connotations of policing a gathering to protect members of the public. But we're told nothing about the basis of that. And similarly with the meeting, my Lord. We're told an official met with a member of Operation Dudula who requested a meeting. Nothing about what they talked about, who the respective people were, not a word on any of that, my Lord. So, my Lord, we turn then to the framing of the order, because this court ultimately is enjoined to grant just and equitable relief. And there are three elements to that order, my Lord: collusion, support, or acting at the instigation. And we respectfully submit, my Lord, that there may be other ways that the court might consider it appropriate to frame the order. But the essence of it, for which a basis has been laid in fact and law is that it's unlawful for the SAPS or the DHA to exercise their powers at the instance of Operation Dudula, which is pursuing unlawful objectives. And my Lord, we listened with care, awaiting an unequivocal undertaking, confirmation that the SAPS and the department will not do that. It didn't come, my Lord. What came instead was reliance on Plascon Evans. You haven't proven it. Not, we won't do it, we haven't done it, we accept it's unlawful. And so we submit, my Lord, that this order is necessary, and we leave the ultimate framing of it in the court's hands. Even if the collusion aspect is found to be overstated, we submit that it's not. But if it were found to be so, then the support and instigation elements of that order we submit have been established. Lord, if I turn then to the issues around Section 41. Lord, one word on the declaratory order, which is sought in paragraph 1 of the draft order in the notice of motion. Mainly I need to deal with the constitutional challenge, but on the declarator, there's little serious opposition, my Lord. The only real opposition is the Home Affairs persisting in the submission that the language is so clear that a declarator is not necessary, my Lord. But we've established on the papers, my Lord, that this practice was happening. Private persons asking other private persons for their papers. It was a widespread practice. It's an inextricable part of the whole modus operandi of Operation Dudula. It was part of the murder of Mr. Nyati. It's part of most of their conduct in the hospitals, at the schools, and so on. And in Prayer 2, my Lord, we seek an interdict against that conduct. Prayer 1 is the declarator that lays the foundation. And so we submit that order too is vitally necessary to protect the rule of law in relation to who may exercise the Section 41 powers. Lord, I must then deal with the responses now raised in relation to the constitutional challenge to Section 41 by both Home Affairs and the SAPS. Again, my Lord, we listened with care. Not a word on the Minister's letter, which I took your Lordship in my main submissions, regarding the use of Section 41 across 4 areas in Johannesburg to conduct joint operations without warrants. And, my Lord, not a word on the SAPS letter defending, justifying the detention of Miss SN, the 15-year-old citizen minor, saying we did this in terms of Section 41 because Section 41 authorizes it. Lord, what we now have from the Department of Home Affairs is that your Lordship must interpret Section 41 to contain all of the constitutional protections about which we complain. At the outset, my Lord, I emphasize that even if they're correct, we say they're not, but even if they're correct, we submit that that is a basis for the declaratory order that we seek in the alternative, that Section 41 includes all of these elements, that it requires a warrant, that it doesn't apply to children, and that it requires a reasonable suspicion. So even if they're correct on that argument, our alternative relief we submit must be granted. But we submit that cannot be so. That interpretation does strain beyond breaking point the language of Section 41. My learned friend for Home Affairs referred to some aspects of the Human Rights Commission's submissions on this issue. But with respect, my Lord, they've misconstrued the ultimate import of those submissions. They quoted one paragraph that was to the effect that Section 41 should not be interpreted to apply to children. But, my Lord, the Human Rights Commission's submissions, the point that it was making there, my Lord, which my learned friend Mr. Foss emphasised in oral argument, is that children shouldn't be dealt with under this legislative scheme. They should be dealt with under the dedicated legislative scheme which has been enacted to provide for children. Not that Section 41 can be interpreted in that way, that we shouldn't even be looking at it. It shouldn't even be in the picture when we're dealing with children. And, my Lord, their submissions ultimately, the Human Rights Commission, which we associate ourselves with, are that it would strain the language of Section 41 to interpret persons, which is the word in the section, to exclude children. And my learned friend relied on the Abahlali and Moyo decisions in that regard. We have nothing to add there. My Lord, my learned friend, again for Home Affairs, gave an example, using himself in the example, of, well, if I arrive in the country, of course I must be expected to present my passport and answer questions about who I am. My Lord, that's precisely the point. That at ports of entry, powers of that nature are appropriate, and quite a different matter from Section 41, that is completely unrestricted as to time, place, or persons. It's a power that can be used anywhere, against anyone, and on whatever basis, or no basis. And, my Lord, the SAPS, in their heads of argument, persisted with the submission that Section 41 must also be allowed to be used in private. In other words, my Lord, in people's homes, places of study and work. That that's legitimate, it's necessary. Without a warrant, my Lord. We submit that that cannot pass constitutional muster.
That's not what Section 41 says.
And, my Lord, in relation to this issue of warrantless raids, my learned friend for Home Affairs says, well, that's not what Section 41 is intended to do. That's not its purpose, to allow warrantless searches or raids. So why are we even bringing it up? Well, we're bringing it up, my Lord, because that's precisely what it's been used to do. On the Minister's own confirmation, in Operation Restore, across the 4 areas in Johannesburg. And the Minister says, well, I don't require a warrant, and no one has challenged the constitutionality of Section 41. Well, we are now, my Lord. My learned friend also referred to the obligation to assist, and again gave the example that, well, if the person is just unlucky, they happen not to have their ID on them, then the police must drive them to their home, the immigration officer must drive them to their home and enable themselves to identify themselves. My Lord, that aspect does appear in the provision, but there's a crucial point here, my Lord. It only kicks in once the person has been detained. It's in the latter part of Section 41. So the request comes, the learned friend submits that there's a duty to answer it. Yes, there is, on pain of criminal prosecution. It's an offence not to answer the questions. You may then be detained, and only once you've been detained, my Lord, does that obligation to assist the person apply. My Lord, we saw what happened with Miss SM. In any event, she borrowed a cell phone from another adult in custody with her to make the call to get her uncle to come and secure her release. But, my Lord, there is no protection in that regard built into Section 41. It comes too late. You're already in custody. Lord, there's reliance also on Section 33(5) of the Immigration Act, which deals with obtaining a warrant to conduct a search. Lord, we understand the submission to be that, well, frankly, my Lord, there appear to be 2 different ways to understand the submission. I'm not entirely sure which it is. The one is you must read Section 41 with Section 33(5). The other is that, well, Section 33(5) is the provision that applies when you're dealing with warrantless raids or searches. So Section 41 isn't even in the picture. We've shown that Section 41 is in the picture. It's being used to do precisely that. But, my Lord, in relation to the other interpretation that you must read the two provisions together, Section 33.5 is prescriptive about what purposes it applies to. So, in other words, when can you apply for a warrant as an immigration officer to search premises? And those are listed in the sub-paragraphs. And none of those, my Lord, involves requesting a person to identify themselves in terms of Section 41. In other words, Section 33.5 simply doesn't apply to that function. It applies to other functions, seizing articles, arresting a person who's illegally in the country, who's already been determined to be illegally in the country. So, my Lord, there's no challenge to Section 33 in these proceedings, or to any of the other provisions that my learned friend for Home Affairs relied on. The problem is Section 41. And that problem is not cured by Section 33 or any of the other provisions of the Act. My Lord, a brief word then on the foreign law relied upon by my learned friend for the police. We dealt with it very briefly in our main submissions, and I'll attempt to be brief again. They rely on Botswana, Namibia, and the UK. Lord, in relation to Botswana, the simple point is that procedure requires notice first. The person gets summoned. It doesn't allow immigration officers to walk our streets or enter people's homes to compel them to answer information or identify themselves. So that's Botswana. Namibia, my Lord, we made the submission yesterday. They rely on Section 8 of the Act. Section 8 of the Act, my Lord, refers to a person presenting themselves in terms of Section 7. And, my Lord, Section 7, which they don't quote or refer to your Lordship, provides a person seeking to enter Namibia shall, before entering Namibia, present himself or herself to an immigration officer at a port of entry. So, my Lord, all of those powers and the consequences that flow from them that they referred to in Section 8 of the Namibian Act refer to people, as in my learned friend for Home Affairs example, arriving at an airport, standing in the queue and being required to answer questions there. Again, not in your home, not on the streets. And Lord, there's one further point in relation to Botswana. There's a further jurisdictional requirement there. Before the person is summoned, the person must be suspected to be an illegal immigrant. So again, it doesn't apply to everyone and anyone at random. It applies to a person already identified by the authorities. A further point in relation to Botswana. Finally then, my Lord, in relation to the UK, they rely on the United Kingdom Immigration Act. They purport to refer to Section 4 of that Act, my Lord. That's an incorrect reference by the SAPS. Section 4 of the UK Immigration Act doesn't contain the provision that they quote. That provision appears, my Lord, in Schedule 2, paragraphs 2 to 4 of the UK Immigration Act, and in fact of an earlier iteration of the Immigration Act that's since been amended. But let's deal with it as it was in 1971. My Lord, the UK Act basically also applies to people arriving at points of entry. Its Schedule 2 is headed Administrative Provisions as to Control on Entry. So, my Lord, again, it applies to people who are presenting themselves either at a land border or at an airport, and really doesn't avail us. And in fact, my Lord, we made the submission. It demonstrates why Section 41 is constitutionally problematic. Because we have always accepted, my Lord, that there is a legitimate purpose to Section 41, requesting people to identify themselves, but only in the appropriate, constitutionally appropriate circumstances. And we've made the submission, my Lord, that three crucial safeguards are missing from the provision. That it should only apply to public places, which would include ports of entry. That it shouldn't apply to children, and that it requires a reasonable suspicion or some other requirement of reasonableness at that first stage of making the request. My Lord, we submit that the language is simply not capable of being interpreted to include those protections. My learned friends for Home Affairs say that the court should interpret person to exclude children and interpret silence to mean with a warrant. And with respect, my Lord, that simply stretches the court's interpretive muscles beyond what they're capable of achieving. So those are our submissions on Section 41. The provision is clearly unconstitutional, and it's necessary for the court to exercise its powers to declare it inconsistent with the Constitution to the extent of its unconstitutionality. We've proposed a reading in to remedy the 3 defects. In any event, my Lord, the order will have no force and effect until confirmed by the Constitutional Court. And we include referral in the order. My Lord, remains to deal with 3 issues somewhat more briefly. On the National Action Plan, my Lord, there's no meaningful opposition, my Lord, we submit with respect. There's again reference to the Hate Crimes Act having been passed. We've made the submissions, it's not in force. In any event, it's not an answer to what the National Action Plan is required to do. And my learned friend referred to that part of our founding affidavit where we appropriately acknowledge that some aspects of the National Action Plan have been implemented. But the bulk of it, my Lord, has not been implemented. There's been a failure to take reasonable steps to implement it, including those 3 crucial aspects that we highlight: the early warning rapid response mechanism, the disaggregated data, and the 3rd aspect that we highlight, my Lord. And, Lord, separation of powers simply cannot avail the respondents in this regard. It's their policy. It's their policy, and they failed to implement it even in the time periods. The time periods are not even ours, my Lord. They set their own time periods, a 5-year period, to implement it, and they've still failed to do that. This is as far from intruding into the separation of powers with respect as it's possible to get. And as to whether the order is necessary, my Lord, it is necessary because they've failed to do so. They've failed to implement those aspects. The court order will be a necessary and vital corrective, guidance to the state to discharge its constitutional obligations by implementing its own national action plan, also necessary to discharge South Africa's international obligations. And my Lord, my learned friend Mr. Mpofu for one of the amici curiae for the ICJ, referred to South Africa's commitments in Universal Periodic Review before the Human Rights Council, where the state committed on the international plane to implementing this very National Action Plan, Lord. And concern was raised in the UPR over the state's failure to do so. So there's an accord here between the international plane and the domestic, my Lord. And the state has already committed domestically and internationally to implement it. Lord, then dealing with military uniforms, and again we can be relatively brief on this, my Lord, starting with issues of resemblance. Both of my learned friends for the SAPS now made oral submissions, taking your Lordship to a very small selection of the photographs, that there is no resemblance. First of all, my Lord, we've been called up on Plascon Evans, and we submit that we've respected its rules, but there is no denial of resemblance in the answering affidavit. The averments are pertinently put, my Lord. I'll provide the reference in the founding affidavit, pages 03-59 to 66, paragraphs 153 to 162. And this is dealt with, or rather not dealt with, my Lord, in the answering affidavit at page 06-18 at paras 90 to 92. And my Lord, the averment is pertinently made in the founding affidavit that the uniforms and clothing worn in the images resembles that of the military, and there is simply no answer to that paragraph in the answering affidavit, to paragraph 154 of the founding affidavit. They just skip it. So, my Lord, it was never put in dispute by any party on the answering papers that the uniforms resemble each other. So, my Lord, the position on the papers is that resemblance is apparent. My learned friend, Ms. Isaacs, picked 4 examples to show your Lordship where she suggests there is no resemblance. My Lord, with respect, they've picked the examples where which best suit their case. We've put up over 30 images of the uniforms being worn. And a proper consideration of those over 30 images, my Lord, confirms the resemblance, which was never put in dispute. So, my Lord, it's a belated point which has no basis on the papers and which this court cannot sustain. There was an additional inflection added to it in oral argument by Ms. Isaacs on behalf of the SAPS, which is that she used the word strikingly, that the uniforms don't strikingly resemble that of the military. She used it repeatedly. There's no such requirement in the Gatherings Act, my Lord. Language is resemble. Lord, there's one further vital contextual submission here, which is that the facts here are gatherings by Operation Dudula, which the papers confirm are associated with widespread threats, what my learned friend for Home Affairs described as crimes, and where, on certain instances, the members of Operation Dudula are armed, for example, at the Masibi House eviction. So, my Lord, with respect, the glib example given by my learned friend for the SAPS of he himself wearing a camouflage cap and fearing being arrested for it ignores the context entirely, and we submit, fails to have any sensitivity for the context and its effects on people. We're not talking about any of us advocates wearing a cap in a shopping mall, my Lord. We're talking about gatherings which are loaded with threat. And my Lord, so that example is entirely unhelpful. My learned friend, Ms. Isaacs, asked the court the rhetorical question, well, how should we implement this? We've already made submissions on that, my Lord. It's very straightforward. We've never argued that there must be widespread arrests or the police should wade into every gathering and arrest everyone who may be wearing camouflage clothing. It's simply instructing them not to do so. A single letter might have sufficed, my Lord, given that there's a single entity convening all of these gatherings. One letter from the SAPS referring to Section 8 of the Gatherings Act and saying that it's unlawful to wear clothing resembling military uniforms and you're instructed to desist from doing so may have sufficed. They did nothing, my Lord, absolutely nothing at any point. And an order to that effect is accordingly necessary, my Lord. Not only declaring that the wearing of military uniforms by Operation Dudula was unlawful, but also in relation to the SAP's failure to address it. Lord, the final theme then that I must deal with in closing, and perhaps appropriately so, concerns human rights defenders. My Lord, this issue arose in the context of my learned friend for Home Affairs' response to the amicus curiae, the UN Special Rapporteur for Human Rights Defenders. And my learned friend made the submissions that amici must confine themselves to their appropriate role, making submissions on the interpretation of the law, domestic and international, but not introduce new evidence and not seek new relief. Lord, there are a number of instances where, in fact, amici have suggested relief, and we submit that is an appropriate role. not to introduce fundamentally new relief, but to make submissions on the relief sought by the parties. That is an appropriate role for amici. But more fundamentally, my Lord, it was submitted by my learned friend for Home Affairs that, quote, "you will not find anything on the papers on human rights defenders being attacked." And my Lord, perhaps this begs the fundamental question, the starting point, what is a human rights defender? And my learned friend Mr. Bhima has addressed this to some extent in his written submissions. But in essence, my Lord, a human rights defender includes an activist, be a faith-based leader.
My Lord, I'm going to object to my learned friend giving evidence on behalf of an amici from the bar. If you look at the affidavit of that amicus curiae, he never tells you what he means by human rights defenders. So it's not open to my learned friend to start now arguing that case. And in his submission, he never made any case about human rights defenders, that their case is based on human rights defenders. And amici was here to assist the court, not to assist him. So as a purpose.
Thank you, Mr. Mukari. Let me just make this point that you made certain submissions, and I've obviously noted what you said there, Mr. Mukari. I'm now hearing submissions from Mr. Bricchio. Again, I'm going to hear those submissions, and I have to decide on the basis of what the legal position is. But I've heard your submissions, and yeah, the role of amicus is obviously clearly defined in our law, and whether you're right or whether Mr. Bricchio is right is something that I'll have to decide upon.
As a court, please.
Lord, the objection is without substance. A human rights defender is defined in an international soft law legal framework. It's law, my Lord, not evidence.
Yes.
And that's what the amicus has put up, which is that international legal framework. It's that framework under which that special rapporteur operates. It's got nothing to do with facts. My Lord, we accept that an amicus ordinarily cannot put up new evidence without leave of the court. It's not our understanding that they've sought to do so. The point I was about to make, my Lord, is that the founding papers are replete with evidence of threats and attacks to human rights defenders.
Yes.
What is a human rights defender, my Lord? In terms of the law, it's an activist or a lawyer. It can be a faith-based leader such as an imam or a priest who plays that role of on the ground, stepping in to represent the rights and interests of people whose rights are threatened. It's a legal term, my Lord. We didn't use the term, but it's a term that exists in international law. And my Lord, the papers, I can give some references. The key section, Lord, is that section of the founding affidavit which laid a basis for the Part A order, which begins at 0313 and runs from paragraphs 26 to 35. And your Lordship will recall the evidence that's set out there that I didn't deal with in my main submissions, my Lord, which is, if we start with the lawyers, the threatening calls to the applicant's instructing attorneys, threatening to subject the applicant's instructing attorneys and candidate attorney, who are women, to sexual assault and violence, the threats that culminated in the applicant's attorneys having to close their offices on several occasions. And Lord, those are... Lord, I haven't placed this on record, but there was a previous junior counsel who acted in this matter with me. That junior counsel withdrew because they were afraid of the threats.
Yes.
I placed that before the court as an officer of the court. My Lord, the threats go far beyond the lawyers, and my Lord, the lawyers are usually the least at risk in these situations. The people really at risk, my Lord, are the members of the four applicants from Kopanang, Saitif, the Inner City Federation, and Abahlali Basenjondolo, who, my Lord, and those incidents, those threats are all set out in that section of the affidavit and throughout the rest of the affidavit, including threats to cut one of the Kopanang leaders and let that person bleed out in front of their child. So, my Lord, the suggestion that there's nothing on the papers involving threats or attacks, human rights defenders, is with respect unfounded, my Lord. It took courage for those 4 applicants and the 30 deponents to the affidavits to place themselves before this court, my Lord, to put evidence before the court of the events that have been unfolding. And Lord, they do so in order to seek this court's discharge of its constitutional function to protect their rights and the rights of other vulnerable persons in our communities in the face of what my learned friend has described as crimes, brazenly, blatantly, widespread unlawful conduct. And ultimately, my Lord, to vindicate the rule of law. Lord, the applicants submit that a case has been made out for all of the relief sought in the draft order. Those are our submissions.
My Lord, with your permission...
Sorry, my Lord, if I may, there may be one further submission from my juniors, perhaps. Eventually. Apologies. My Lord, I've been requested to place on record that there is a member of Operation Dudula present in court who is currently taking photographs of the persons present in court, including legal representatives, without their consent, and posting those on social media. I simply place it on record.
Thank you, Secretary. If that is happening, I should ask whoever is doing that to immediately stop that and to delete those photographs.
Apologies, she's actually left the room after I asked if I could see if she is taking photos. She's left the courtroom, so she's not here right now. But I assume those in the courtroom.
Yes, Mr. Mukari.
My Lord, just with your indulgence, I just want to deal with one aspect which arose in reply, which is a new matter because it's not an issue that we had an opportunity to argue. Because my learned friend, in argument in chief, he said Plascon events doesn't apply to their case, you shouldn't apply it. Now in reply he says that it should apply, but then he says that in respect of the prayer on collusion, then the court should grant any other relief, which we have not been told what it is. So I'm just saying that it is not appropriate that in reply, then a case changes now to something else which we never had an opportunity to deal with. So your Lordship will just take into account those submissions.
Yeah. Sorry, Mr. Mukari, I understood Mr. Brickhill to accept
Yes.
that, especially when it comes to the factual assessments in trying the facts in the matter. For starters, Plascon Evans it's been developed, that principle.
Yes, absolutely.
Over with Whitman and the other matters as well.
Yeah, that's what was arguing in reply. So that's the point that, we never had an opportunity
to... Did he say something different in his main argument?
In his main argument, he said that then you shouldn't apply Plascon events because this is not a commercial matter, it's a constitutional matter.
Well,
so just making
that, I'm sure he's not persisting with it. But I think that the point is taken. I understood and I needed clarity on this issue. That when it comes to making an assessment of the facts in the matter, that Plascon Evans applies here.
Yes. No, absolutely.
Irrespective of whether or not we're dealing with the constitutional matter or not, you still need to establish a basis, factual basis on which we apply the law and or whether or not constitutionality is challenged.
No, you're absolutely correct. So that's why I had to argue Plascon events, which I didn't have to ask. And I didn't have to argue it when I was arguing because of his submissions in chief. But then the concession, of course, is well made. But the point I was making was that now results in having to him argue the case to defend the position which he was not defending in chief, which he never had an opportunity to do, and to even say that now the court, in respect of the collusion support, the court then can just give any other order that it wants to do, which we are not even aware of what it's talking about. So I'll just bring that to your attention.
Thank you.
Thank you. As a court, please.
I want to thank you and Mr. Brickell and all of the other counsel and your teams, obviously for the written heads of argument and for the submissions made during the hearing of the matter. Needless to say, I've been given a lot of food for thought and I need to mull over what has been said here today. For that purpose, I intend reserving my judgment and postponing the special motion sine die. As soon as we're ready to hand down the judgment, we'll let the attorneys know that we are ready and advise them of the date and time on which the judgment will be handed down. So for now, in sum, the special motion is postponed sine die for my written judgment, which is hereby reserved.
As a court, please.
As the court, please.
Yes, thank you everybody. Court adjourns.